Very often people ask, what is assault and battery in Illinois? What does it mean? What does assault or battery mean in a criminal setting in an Illinois courtroom? Join me for a minute. My name is Steve Fagan of the law firm of Fagan, Fagan & Davis, an attorney practicing criminal defense in Illinois. What we're going to talk about is assault and battery. And the fact of the matter is, there is no such single thing as assault and battery in Illinois. It's not described that way under the law. There is battery and there is assault. They're two separate crimes. The difference is confusing, so let's spend a minute talking about it. First of all, battery can be described in two basic ways in the law. The first is the most common. It has to do with causing bodily harm to another. The legal definition is knowingly, intentionally, and without lawful justification, causing bodily harm to another. Knowingly or intentionally, meaning you didn't do it by accident. Without lawful justification, you didn't have a legally valid reason to hit that other person. For instance, is self-defense a lawful justification? It may be. It's what's called an affirmative defense in Illinois, which means you have to prove it. But nonetheless, it may be a lawful justification. A different way that battery can be charged in Illinois is less common, but it happens. It's called knowingly or intentionally touching someone in a way that you knew or should have known is insulting or provoking. Now, there are many different ways that this can happen. The most common is you're in an argument with someone and you poke them in the chest. Is that insulting? Probably. Is it provoking? Most of the time, it's meant to provoke a response. So, that's one way that a battery, for instance, can be charged. A different kind of offense entirely is assault. And assault doesn't necessarily mean you've touched anyone. As a matter of fact, most of the time, you didn't touch anyone. Assault is, once again, knowingly or intentionally placing someone in what's called reasonable apprehension of receiving a battery, meaning you've threatened them in a way that makes it believable that you're about to hit them, for instance. In other words, if another person believes you're about to commit a battery, you've given them a reason to believe that, and you knew you were doing that, you might be charged with assault. Typically, assault or battery are both charged as misdemeanor offenses under Illinois law. Nonetheless, they're very serious because the type of misdemeanor is the most serious type of misdemeanor. It's called a Class A misdemeanor, punishable by up to 364 days in jail and up to $2,500 in fines. So it has to be taken seriously. Now, under many circumstances, assault or battery can be charged as a felony. And there are many possible ways that can happen. In either case, you have to take these cases very seriously. If you're facing criminal charges of assault or battery, call us at 847-635-8200. We'd be happy to talk to you. Have a great day. Thanks for joining me.